the National Director for Women and Law in Southern Africa. As you may be aware, Women and Law in Southern Africa is an NGO that works to protect the rights of women and girls in Zimbabwe. And our major interventions are through challenging laws, through evidence-based research, and also providing legal services. So among other things, we help women and girls to realize their constitutional rights through mounting strategic impact litigation. This is the reason why we are here today. In 2022-2023, we did an application in the High Court. It's a constitutional application where we were seeking to test a provision of the law against the constitutional validity. So we did a constitutional application in as far as the Termination of Pregnancy Act is concerned. And I'll start off by giving you the background of the case, and then I'll go into why we were motivated to do such an application. So the case is the case between Women and Law in Southern Africa, being the first applicant, and we had a young girl who was a victim of, who was affected by the provisions under review. She was the second applicant. We were litigating against the Minister of Health, Child Care, the minister being the administrator of the responsible act, which is the Termination of Pregnancy Act. We were also suing against the Parliament of Zimbabwe in its official capacity as the legislature. And we also sued jointly the Attorney General of Zimbabwe, being the overall advisor of government and government, yes. So what we were looking at in this case, we were, as I said, we were making a constitutional application. Rather, we did a constitutional application in respect of Section 2, subsection 1 of the Termination of Pregnancy Act, Chapter 15.10, which I will refer thereafter as the Act. And what we were seeking through the application was to allow children before the age of 18 and married women who are victims of marital rape to have access to legal abortion as provided in Section 4 of the Act. As our legal counsel will explain, currently under the provided Act, the ground upon which termination of pregnancy can be allowed within the scope of the law, it's provided for in Section 4, which grounds are very restrictive. So as we mounted the case as WLSA, we were seeking an expansion of that ground. Specifically, we were looking at young girls who are not married, and we were also looking at women who are in marriages. So we were then saying in respect of young girls, girls who are below the age of 18, they don't have capacity to have, to consent to sexual intercourse. Once they fall pregnant, why should they continue with their pregnancies? And we were also saying in marriage, in as much as one is married, they still have the right to say no or yes to sex. Once sex is obtained without consent, it becomes rape. Therefore, we were seeking through the law to have victims of such sexual violence be protected just as anybody else who's a victim of unlawful sexual intercourse. So essentially, we were looking at the term unlawful sexual intercourse as it is provided currently under Section 4. And then we realized that the scope within which legal abortion can be obtained within the definition of unlawful termination, it's almost impossible under what is obtaining in Zimbabwe. So we were looking then to persuade the court in as far as the protection of children to have enhanced protection in as far as access to legal protection is concerned. And we were also seeking to give effect to prior litigated case, which is the case of Mudzuri. And another, I think we are all aware of the Mudzuri case, which is a case around child marriages, where the Constitutional Court gave a positive judgment in as far as child marriages are concerned. We were also seeking to give effect to the case of Chiwenga case, which case also speaks around the age of sexual consent. Why is this case is important to WLSA? The case is important because it speaks closely to the mandate and work of WLSA. Just as I said that our work is to protect and promote women and girls' rights in a broader sense, but lately we've been focusing and zoning in as far as sexual reproductive health rights are concerned. Why do we zone at a particular time? We're doing so because we have noted that sexual and reproductive health rights, it's an aspect of the law, it's an aspect of human rights, which remains without much conversations, which remains without much legal protection and constitutional protection. So we were also emphasizing and seeking to give effect Section 81 of the Constitution, which provides the rights of children. So we were seeking to enforce protection of children in as far as their sexual reproductive health rights are concerned. So we were also informed by the statistics that are obtaining in as far as abortions are concerned in Zimbabwe. Admittedly, the law does not permit abortion in Zimbabwe unless and until given a confirmation to abort. Nonetheless, there are backstreet abortions that are taking place, and these backstreet abortions are often taking place within the age of adolescents who ordinarily cannot afford safe abortions. So we were armed by a number of statistics, which statistics I would want to share with you. Literature, research, some of the research WLSA has already done, have established that 40% of pregnancies in Zimbabwe between 2016 and 2017 were unintended. And 25% of such unintended pregnancies do end up in abortion. And often such abortion is illegal. And once it's illegal or deemed to be illegal, it takes place in unsafe and unhealthy conditions. And around 2019, according to Parliament of Zimbabwe, there were 80,000 abortions in Zimbabwe. And of the 80,000 abortions in Zimbabwe, they translate to 219 abortions per day or 9 abortions per hour. And of these abortions, about 18% are abortions that take place within the range of adolescence age. So, however, without safe abortion being allowed under the law, adolescents often find themselves resorting to backstreet abortions for 2 reasons. One, fear of the law, and secondly, they do not have access to safe and legal abortion due to medical costs that are involved. So out of this case, we have received a judgment. I think the legal counsel will give further details about the way forward. But what we have obtained today as we speak is expanded protection of women and girls under the broader framework of sexual reproductive health rights. The High Court, through the application that we made, confirmed that indeed Section 2, subsection 1 of the Termination of Pregnancy Act is unconstitutional, in the sense that it does not seek and confirm the spirit and letter of the Constitution. The spirit and letter of the Constitution, among other things, promotes and protects children's rights. The Constitution also protects and promotes women's rights. So the Termination of Pregnancy Act, in particular Section 2, Paragraph 1, being put against the Constitution and its spirit, it failed the test. Put simply, it therefore means that what the Constitution is saying and what the Termination of Pregnancy Act is saying, they are not in tandem, they are inconsistent with each other. And as we know, an act or a provision of an act becomes invalid to the extent of it's inconsistent with the Constitution. Why so? Because the Constitution is the supreme law of the land. So as women and law in Southern Africa, we are happy to have received such a progressive judgment, which judgment is upon being confirmed, as will be elaborated further by the legal counsel, we are going to see an opening up of the ground upon which legal termination may be obtained in Zimbabwe, especially within the age group of adolescents. Adolescents, as we are all aware, do have access to sexual intercourse just like any other adult person. And more often, they do so without using the necessary protective measures. Neither are they using any family planning methods, and resultantly, that results in pregnancies, which pregnancies, whether we like it or not, end up being terminated using very dirty methods, needles, a lot of concussions, etc. And this has really impacted and increasing in a number of deaths, as we have established through evidence-based research. So we are happy to have received the judgment, and we are hoping that in as much as we are protecting women and girls, women, particularly in marital statuses, are also going to be protected and promoted from marital rape, where should they choose, they will be able to terminate the pregnancy, which result is as a result of that marital rape. Thank you.
Thank you very much, Ms. Ishiane Suchirisa, for giving us the context of why the application was made and also the issues that needed to be addressed. So now I'm going to call upon the legal counsel to the case, Honorable Tendai Biti, to give us an explanation of the application, the implication of the judgment, and the next steps. Honorable Biti.
Thank you very much to WLSA for inviting me to explain your judgment. I think from what Anesu has said, abortion is a big issue in Zimbabwe. As she has said, there are 80,000, 90,000 abortions that are taking place in Zimbabwe every year. And that translates to a figure of 219 to 250 abortions per day, which averages, she says, to a minimum of 9 abortions per hour. So as we are sitting here, somewhere in some backstreet laboratory, somewhere in some hut, an illegal abortion is taking place. And a third of those people that are aborting, they actually die. The mother and the child actually die. And unfortunately, the majority of people that are actually dying in those backstreet abortions are children. And children are defined to mean any person below the age of 18. So WLSA found itself with a problem. Women's organizations found themselves with a problem. The problem that they had was that we had a law and a constitutional judgment in 2016 that said that young children can't be married. So the case of Mudzuri and others outlawed child marriages. However, that judgment was pyrrhic. That judgment was hollow in that whilst women, children, adolescent children could no longer be married, there was nothing that prevented sex from those children. So, in fact, one of the ironies that that judgment brought was a man saying, I can't marry you, I really wanted to marry you. you are 17 years of age, but the court said, I can't marry you, but I can still have sexual intercourse with you. So it was a contradiction in terms. Fortunately, the Constitutional Court, through again the fight brought by women's organizations, in the case of Diana Eunice Chiwenga, said the age of sexual consent is 18. So you can't marry before the age of 18, you can't have sex before the age of 18. But we had a problem. Whether the law says there will not be adolescent sex, we know that there will be adolescent sex. The question that arose then was, what happens to a child, to an adolescent, who then finds himself pregnant from an act of sexual activity that the Constitution has outlawed? And this is where WLSA came in now and said, we have to protect children. It's abusive. It's unconstitutional for a child to carry another child. So they went to court. But when they went to court, they were facing a challenge in that, as Anos says, legal abortion in Zimbabwe is sparse. The provision of the law is very restrictive. The law says you can only have access to abortion if the pregnancy is a threat, a serious threat to the health of the mother, the physical health of the mother, which means only in exceptional circumstances. The law also then says you can have abortion if the pregnancy is as a result of unlawful intercourse, as defined in section 2(1) of the Termination of Pregnancy Act. Unlawful intercourse is defined to mean rape or prohibited incest. Not all incest is unlawful intercourse, but of some degree. You can't sleep with your sister, you can't sleep with your child, and so forth. You can't sleep with your cousin. But the distant relationship, they are not. So, to the extent that unlawful sex with an adolescent was not defined as unlawful intercourse for the purposes of section 2(1) of the Termination of Pregnancy Act, WLSA's argument was that leaving that, excluding this unlawful intercourse with children from the definition of unlawful intercourse, which allows legal abortion, was unconstitutional. The other thing that WLSA had a problem with was, a few years ago, after years and years of struggle by women's organizations, marital rape was criminalized. And marital rape is now a reality in Zimbabwe, because you've got thousands and thousands of our people that go in the diaspora. So the wife goes to the diaspora, the husband remains and marries another woman. His life goes on. He has my day, he has Susan, he has Sylvie. The wife comes on holiday. They've been separated for 10 years. The husband, who has moved on, knocks on the door at the hotel where the wife is staying and says, "You are still my wife. I want to sleep with you." The wife says, "But you have moved on." And remember, most marriages in Zimbabwe are unregistered customary law unions. So the divorce is not formal. And that's that. So there was a problem until the government came to the aid of women and said, marital rape is a crime. If you sleep with someone and allege you are my wife, simply because you had a matrimonial liaison, it becomes a crime. So, but there was a problem now. This woman then gets pregnant. She, of course, has been raped, but it's still marital rape, but it's not one of those things that are defined in the definition of unlawful intercourse for the purposes of section 2(1). So WLSA then said that you can't exclude marital rape from the definition of unlawful intercourse. Marital rape should also be defined as unlawful intercourse. The court, the High Court of Zimbabwe, gave a very progressive judgment. The court said, if we protected children and said children can't be married. In the case of Modzuri in 2016. And the age of sexual consent is 18, as we said in the Diana Yunus-Kawenda case in 2022. Then surely we must allow this child who has been evicted, because the child is deemed not capable of having, of saying yes to in sex. We must protect this child by allowing her to have access to lawful abortion. And given the huge numbers, the terrible statistics of 9 abortions per hour, of which a third are illegal, it makes sense that the law protects and gives access to legal abortion to these young children. And I want to thank WLSA because we live in a very conservative society. So some aspects of our society might not accept how important this is. But if anyone there is a father or a mother or an aunt, you know the reality that our children are being abused. Whether we like it or not, our children are sexually active before the age of 18. And more so in the rural areas. The majority of young people that are going through illegal abortions are actually people from the rural areas, people that are poor. Those in Borodale will take their children through a first-class ticket to Senton for illegal abortion at a Mary Stoppers center. So it is the people who are in Lotito, in Chendambuya, in Nkai, in Cholojo. Those are the young children that are dying. So WLSA needs to be commended. What is the next step from here? The next step from here is that in terms of Section 175, subsection 1, the Constitutional Court must now confirm this judgment. We are very hopeful that the Constitutional Court will confirm this judgment, for it is the same Constitutional Court that gave us the case of Modzuri, the child marriage case, that gave us the case of Diana Yunus-Kawenda. So I'm very, very hopeful that the court will continue in its very progressive, assertive role in protecting women and in protecting children. But once again, let me thank WLSA and the Progressive Women's Movement for a very broad, for a very brave public interest litigation that you took on, and long may that continue.
Thank you very much, Honorable Biti, the legal counsel for the case. And now, as we've heard, the women's movement has for a long time waging a war against reproductive justice for women and girls in Zimbabwe. So to do that, we are going to ask Mrs. Edna Masiwa, the Director of Women's Action Group, to give us how this judgment has been received by women's rights organizations.
Okay. Thank you very much, and thank you to WLSA for taking this up. I think as women's organizations, we've been working on this issue of access to termination of pregnancy for women. And I want to also highlight that we are being ruled by a law that was put in place 47 years ago, 1977, a law that does not serve today's woman. It talks about 2 doctors have to confirm if a pregnancy is to be terminated. But how many doctors do we have in Mbire, for example? Do we have the 2 doctors? So we are all saying this law, yes, it's there, but it's not even serving today's woman. We are also saying we are holding to this law. We don't want to talk about abortions because of some moral values and so forth. But we are saying this is an issue that is affecting women. I would take you back to the 1980s when AIDS came. AIDS affected men mostly, and it was taken on board. And before we knew it, we had a law on HIV and AIDS. We started having our tax collectors also collecting AIDS levy. So we are saying let's put our heads together and see how best the issue of unsafe abortions can be addressed in Zimbabwe. I want to highlight that at the moment, we have what we call a Safe Abortion Coalition. This is a group of organizations who are working on the issue of abortion. And we are focusing on advocacy for the expansion on circumstances. That's why we are very appreciative. We are welcoming the judgment that WLSA got, because there is expansion. We are also looking at if expansion could also consider the economic status of the woman who wants to terminate their pregnancy. And secondly, we are also raising awareness on the current termination of pregnancy law. Because what we are seeing in the communities, even those who have had unlawful sex and fallen pregnant, are not accessing termination. Why? Because the health delivery system is not even alert to this challenge of unsafe abortions that are happening. And also the women and girls out there are not aware of the law that can also save their lives. I want to talk about unsafe abortions and how they contribute to maternal mortality. It has been said that unsafe abortions are the fifth contributor to maternal mortality, which currently stands at 362 deaths per 100,000 live births. And when we look at this Sustainable Development Goals, by 2030, we should be at 70 deaths per 100,000 live births. At the pace we are going, I don't think we will get there. Another observation is our government, through the Ministry of Health, has put in place a post-abortion care program. And what we have seen is it's more expensive to treat someone who has had an unsafe abortion as compared to offering a safe abortion. So we are saying, why not offer women safe abortions? Because they need those abortions. We also have learned that if a woman decides that they don't want to carry on with a pregnancy, they will find a way to terminate the pregnancy. What also we are finding out is abortion has become a class issue. Those who have money can have safe abortions, either in Zimbabwe or across the border. So the issue of abortion has become an issue for those who do not have, those who cannot afford to pay doctors, those who cannot afford to cross the border to access safe abortions. We also have noted through our work that one who is against abortion today is for it tomorrow. For example, if your child is to get a scholarship to study outside of the country, and you discover they are pregnant a few weeks before they travel, we have seen people seeking abortion services. And we have seen some even going for unsafe abortions, which then complicate. So we are saying, let's continue working around the issue of access to safe abortion. And it takes all of us to be on board so that we push this agenda. I have heard people who then get surprised when they hear we are working on safe abortion. But I want also to acknowledge that through the work we have been doing on abortion, there have been so many stories written on abortion in different media spaces. And for me, what really is encouraging me is the slant of the stories. The stories are not blaming women. The stories are putting across ideas to ensure access to safe abortion. I also have noted that our law is so strict on those who have had unsafe abortion as compared to those who have had committed infanticide. Then you wonder, then the thinking is if someone commits infanticide, they are under pressure and so forth. But we don't even think about this little girl who is in Form 3 and finds themselves pregnant. What pressure, what is the amount of pressure that girl goes through? So as a country, we can't be allowing 9-year-olds to deliver. Let's offer safe abortions. I'll end here for now.
Thank you very much, Mrs. Masiwa. I'll now ask Sharon Mashamba from the Women's Coalition of Zimbabwe, who is representing the health cluster as the vice chairperson, to also aid their voices on how the judgment has been received by the women's movement. Thank you very much.
I'll sit as my predecessors. Thank you very much, Rosa, for this landmark. It's really something to celebrate, something to look at, and something that we have been waiting for too long. As the Coalition of Zimbabwe, we celebrate this judgment as a significant turning point for our country. It's powerful affirmation women's rights to bodily autonomy by declaring Section 2.1 unconstitutionally to the court has reinforced Zimbabwe's commitment to upholding the rights of women and children as guaranteed in the constitution. Marital rape through criminalization is previously excluded from the Act's definition of unlawful intercourse. Further trauma is breached in Section 53 of the Constitution. We therefore celebrate this ruling as it acknowledges the women, regardless of their marital status, have a right to dignity, autonomy, access to health, and including self-abortion. We believe it is essential for women and girls to have access to safe and legal abortion services to protect their health, well-being, and autonomy. When we look at the statistics that are spoken about abortion, we realize that this is an issue that we cannot look at and keep it as under the carpet. We are looking at approximately 22 million unsafe abortions. We are also looking at 47 fatalities and millions of additional injuries to women as they go through the backstreet abortions. As the Women Coalition of Zimbabwe, we firmly believe that the court's decision is not just a legal outcome, but a call for action for the women's movement. We advocate for the following issues. Existing laws and policies should align with the court's ruling by creating clear pathways for victims of cases of abortion. The government, through the ministries of health and child care, should implement comprehensive sexual education and ensure that quality reproductive health care services are widely available, particularly in marginalized communities. The government needs to enhance the support provided to women and girls and include the provision of maternal health support. Ladies and gentlemen, I thank you for gathering here and taking this issue seriously. Thank you very much.
Thank you very much, Women's Coalition. Now we want to hear the voices from women representatives in Zimbabwe. So we're going to call upon Talent forget to come and just speak out on what this judgment means to ordinary women in Zimbabwe. Maybe you can represent the women from the economic hubs in their absence. So may you just come through quickly.
So, my name is Prudence Anyani. I'm coming from one of those marginalized communities where abortion takes place. Those figures that were being talked about hourly, minutely. So this landmark court ruling brings about change to our communities. Women and young girls can access safe abortion. It's a tool that cannot be used by survivors of marital rape, even rape cases of teenagers. This is going to reduce cases of maternal death. You realize that most women die. One, you are carrying in pregnancy that you don't want. The effects, mental effects that pregnancy has on a woman become so many that at the end, she's not able to give birth safely. So I'm applauding this landmark court ruling is something that is going to bring a lot of change to women who are out there. As has been said before by others, cases of unsafe abortion occur mostly in communities where people don't have enough resources to go to for safer abortions. But now with this ruling, is WLSA and all the stakeholders continue to have it to be aligned with the Constitution, women are going to be able to access a safer abortion, as I already alluded to. We are so happy, and we hope WLSA and other stakeholders will continue to take up issues that involve women, issues that have been left behind, that people feel they don't really matter. 1977 is a long, long time. And such laws there should have been changes. But I guess because, I don't know whether it's patriarchy or what it is, we have left it for 47 years, while women and girls are dying. We are happy for this change. We are happy for this court ruling. Thank you.
Thank you very much, Prudence. Ladies and gentlemen, now we've come to our question and answer segment. So you're open to ask questions. Questions? Yes, thank you very much.
Thank you very much for the presentation, and once again, I'd like to congratulate WLSA on the landmark judgment around SRHR and termination of pregnancy. So I really like to allude to what Mama Siwa said, that we're dealing with the 1977 Termination of Pregnancy Act, where possibly the context around teenage pregnancies was very different from what obtains now. So I really want to point to the real defect that we have, which is a 1977 Act, as opposed to the context in which obtains now. So my question is to the panel: what opportunity do we have to review or overturn the 1977 Act so that it speaks to the issues that are obtaining now in terms of SRHR? Thank you.
Thank you, Ivy. Any other question on the panel can respond? Yes, please.
I will do my part, and then Mr. Biti can also respond, because this is a legal question. So maybe you realize that when we are dealing with cases of challenging legislation, its content, you can either go wholesome or you can target specific provisions. There are certain advantages and certain disadvantages for either approach. So I think this is a reflection which is already there, whether to do a comprehensive approach against the whole termination of pregnancy. And I totally want to agree with you that the spirit within which any piece of legislation was enacted before independence is completely different. In as much as it was speaking to particular issues, there was also the issue of colonialism, which is something that's no longer obtaining now. So we weighed in around seeking the total nullification of the act against its constitutionality. And then we felt probably at this time it could be more beneficial to go incremental. So we sought and did the application around section 2. But this is conversation, and these are reflections which are still evident around their necessity. So it's another approach that we may also be taking. But like I said, there are pros and cons of doing either way. Ms. Biti, would you want to add on that?
Yes, thank you very much, Anisu. The way I see it, I urge the women's movement to go full Monty and not to apologize. And I urge a multifaceted approach. Only last week, the Parliament of Zimbabwe abolished the death penalty. 2 years ago, I've been fighting the death penalty throughout my life. 2 years ago, that wouldn't have happened. I've been to the Constitutional Court and lost so many cases on the death penalty. But only last week, they abolished the death penalty. So I urge the women's movement to approach the lawmakers, to find champions in Parliament to push this. On the death penalty, I think we were lucky in that President Mnangagwa doesn't personally believe in that. No one has asked him about this issue. I think we need to engage the lawmakers so that we also try to push through the legislature. As far as the legal approaches, I think you should still continue doing that. The Termination of Pregnancy Act is a very harsh law. It imposes harsh penalties, custodial penalties on women who carry out illegal abortions. But what about the men who donated the sperm?
Yeah.
Where is he? Why is he not being criminalized? So it's a fundamentally discriminatory law. And our constitution is founded on equality. Section 56 of the constitution says there is equality between men and women. And here is a law that is fundamentally unequal because it is criminalizing the victim. The woman is the victim of some errand, drunk, a lumpen who would have run away. Who probably is a married lumpen for that matter. So I think that on its own is problematic. I remember many years ago, I acted for a woman called Mrs. Wazar, Rukudzo Miriam Wazar. So she had been expelled at Belvedere Teachers College. And one of my fundamental arguments is that these pregnant women that you are expelling at colleges, you are not expelling the pregnanting boys.
Yeah.
They remain on campus. They complete their degrees. They remain to impregnate other girls as well. But they are not expelled from And the court bought that. And it's a point that I'm at. And abortion is primarily focused on the woman, the victim, but the man is not penalized. That on its own is a problem.
Yeah.
But the real issue here is the right of a woman to have control over her body. When I wake up in the morning, I shave. I've got about it, as you can see. It's my constitutional and democratic right to have control over my body. The woman too should have control over her body. So we are using backdoor arguments. So here we say children, you need to include them in the definition of unlawful intercourse. Married women, marital rape, it's backdoor argument. The real argument that the women must confront hateful is, what does it mean being a woman? Control. It's about control. Section 51 of the Constitution of Zimbabwe protects the right to human dignity. Can there be dignity without control?
No.
I can see the women here, some have got dreadlocks, some have got weaves, some have got, some are slaying, some are not slaying. It's your constitutional right. Nobody asks you to dress the way you are dressed, but it's a choice you made.
Yeah.
Can you imagine if your husband was saying, I don't want you to put on a miniskirt? There will be a divorce in that house. What more something so fundamental is a pregnancy? So I think that you must grab the bull by the horns. In Shona we say, kujga imbwa hono. Eat the big dog.
Yeah.
Don't eat the crumbs you have been doing. This judgment is important, but we fought it through a crumb method. We were under the table, using an argument that no one can say no. Let's confront them on the real argument that, look, I'm a woman. I am entitled and I have reproductive rights. I should choose. I should make a choice. But the law as it stands too, even for, you mentioned, Mrs. Masai, that there are people that are giving birth when they shouldn't be giving birth, because just getting those certificates from doctors, the bureaucracy.
Yeah.
Some of the women that are raped, some magistrates are insisting that let there be a conviction. Our criminal justice system moves so slow.
Yeah.
By the time a conviction takes place, the woman would have had 3 children.
Yeah.
Because it can take 4 years before So we can't be arrested. Women can't be arrested by a law that was made by Wharton Rhodesia during Ian Smith's time. Something is wrong there, fundamentally wrong.
Yeah.
So I think that you've got a lot of work to do, and I'm glad there's so many of you here as women speaking from different constituencies. Remember, you are the voice of the voiceless. This case is not going to be felt in both of them. It's going to be felt, as she was saying, in Highfield, in Dombotombo Marondera, in Vengere, in Lotito, where I come from. Those are the people that you have given a voice. Those are the people that you have given empowerment. So I hope you can continue confronting the bull by the horns.
For me, I know you said it's a legal issue, but for us, we feel it's not really a legal issue. Yes, this we celebrate, but it also is mobilizing us around an issue. So the opportunities now, where there's so much noise around issues of access to abortion. So let's come together. As I said earlier on, we already have a safe abortion coalition. Let's come together, re-strategize. We really appreciate the legal route, but we can also get some other routes, because already we are talking about self-managed abortion, because there are countries who have taken that up as well, and they are pushing that agenda following the issue of bodily autonomy and integrity. My body, myself. We are talking about choice. So we really have to come together and see how best we navigate the space towards choice, freedom to choice.
I guess also this judgment empowers more women, especially in the communities that we're talking about. you realize that cultural norms, religious norms, definitely say it's a definite no where cases of abortion are concerned. But now, when it's written in it's a law, women get more traction. You get more power to exercise that right. You have somewhere to back on. Usually in the community that I come from, women have no say. Maybe because we are not well informed. If you go to the area that I come from, talk about the right to information, access to information. Most women don't know about it. So I believe this ruling will bring a lot of information, will change the women, the way that we articulate, we take law, the way that we communicate nemutemo chayo semadzimai. Because pamwe pacho tiri kutadza kucommunicata nemutemo tichiushandisa nekuti hatisi kunyatsounzwisisa. Saka baba vakataura kuti abortion chitema bhaibheri rinodaro, and ndatoshaya kwekuenda, zvatopera zvakaita sei zvakadaro. But now nemutemo uchitisaidzira pamachanges achiitika anoita kuti mutemo uyu unatsotifambira zvakanaka, zvinhu zvinotinakira semadzimai.
Yeah, thank you very much. I also want to weigh in to say whatever that happens, the law must actually come to grassroots. Mudzimai ari down there, ari down kuchikombedzu. Haasi kunzwisisa mutemo. It intimidates us. Vari kutaundi vacho. We don't understand kuti tinayo mitemo inotishandira papi. Where tinoenda kupi, all those steps. I think those are the issues that we need to also interrogate henceforth. To say yes, that voice should amplify. That voice should be there. Kuitira kuti madzimai ese awane mitemo anzwisise kuti law haipo pakuvasunga, iripo pakuvaprotecta. And also challenging the patriarchy. You find kuti baba kana vataura zvavataura, that works. I'm thinking of a person, Arepa, Nasekuru, or whoever who is close to them. First and foremost, they're told not to say it. And worse still, they're going to live with this pregnancy until they have a child. And what does that happen to her? How does she feel? In terms of her mental health as well. So all these issues, let's interrogate, let's speak out, let's give information, let's empower each other to be able to fight against these laws. Thank you.
Thank you very much, members of the panel. I recognized some more hands. Let's open again another round of questions. There were some hands. How many? So that maybe we just take another one last, because I'm also cognizant of time. There are some members of press who want to leave by 12. So one question, is there another hand? So please go ahead and ask your question.
But still, that case. And also by showing investment in our hospitals. I think for my case, the same thing I had a miscarriage. Then the ballet from hospital, local hospital department. She was in the biscuit because I had my doctors and somebody, two doctors should approve. But the guy is a side effect. You have to buy. Mazimai kungalala bed from a year about 20 on side effect. They need to go. That was nobody that the best property service the following morning, of which was supposed to be an agent, likely less than Biti. Now, let's go and open despite the activity, usually even illegal. So, even as women and law in Southern Africa, we have also noted that even under the circumstances where the law permits abortion to take place, I think we are all cognizant of the Mapingure case. There's a lot of hesitation. There's a lot of duty lapse. There's a lot of negligence around how termination can be done. And even with the law itself, there's a lot of blaze. There are a number of blaze and lack of clarity. So what we are going to do as Women and Law in South Africa is a way forward. We have a project where we are going to develop a guide on the ABCs of legal termination of pregnancy. Just to say, we are also going to advocate for specific time to cut off unnecessary delays, which delays may then cost a life. We are also going to give a very instructive note or guidelines on how one can approach the relevant authorities when they're seeking legal abortion, so that the undue delays are all curtailed. You realize when you read the Mapingure case, there was a number of back and forth, go to the police, go and require a police report, go and require a medical certification, some of the things that are not even provided for under the law. So it then speaks to the huge socialization around the termination of pregnancy. It's just people trying to bring a moral ground into legal processes. So probably in your case, it could be the undertones, which are often not conversated around, which are often not spoken to, but it's just the issue of the undertones around how we are socialized as a country. So we are simply saying this is a constitutional issue. It has nothing to do with morals. It has nothing to do with judging one another. Neither does it have anything to do with the religious issues. If anything were to go by, a lot of people are getting sexually assaulted within the church spaces, which spaces ought to be very safe. We have had a lot of people who have become victims of sexual violence by the papas, and they go scot-free, and they are left to deal and probably handle unwanted pregnancy. So this is where we are stepping up, and I would want to say thank you, Mr. Biti, for giving us maybe the courage that we as women rights organization have been lacking. We need to take it up, even if it means challenging the whole Termination of Pregnancy Act. The time is now. We have to do it. Because when you look at it, often when the conversation around terminating a pregnancy, sometimes when the pregnancy is unwanted, it's a conversation which actually goes between two people. You go up front as the person who's carrying the unwanted child, and then you get arrested, and then you get all this probably stigma and stereotyping. Recently in Bulawayo, we have a case where a 16-year-old was sentenced to 9 months for having terminated. She actually went through a safe termination, and then the community spied on her. She was handed in, she was arrested, she pleaded guilt, and she was then eventually sentenced to 9 months. Of course, she was given community service. But look, this is somebody who's 16. She's starting her life already with a criminal conviction. When they have to vet you, do you have a criminal conviction? You say yes. For what? For having exercised my right. I didn't want the baby. I was not ready to have a baby. And then I terminated it. Already, you are a criminal convict. You are a pervert already when we're talking of the law. So look at these results, these consequences only affecting women. It's an issue of power. Yeah, so we are moving forward, and we want to thank you, Mr. Biti, and thank you, Maima Siwa, and the voices of women are going to be very sharper around this issue because we are seeing the negative effects. Thank you.
Are there any other questions? This brings us to the end of the presser. Maybe let's give a round of applause for panelists.